Okay, I think we will start slowly. So my name is Pauline Duranvial. I'm the CEO of FERA, the Federation of European Film and TV Directors. We have a couple of uncertainties on how to start off the meeting, which is why we're a little bit delayed. But overall, everything is lined up for this program to take place in a proper way, let's say. So first off, I should really excuse my colleague from the Federation of Screenwriters in Europe, David Kavanagh, who is unfortunately sick at the moment and could not join us today. We will, I will miss him a lot, because that means that unfortunately you are stuck with me for the next few hours as your moderator. But thankfully we have a bunch of great speakers to actually take you through the program for today. So as a brief introduction, this to remind you that this webinar is part of a series which is itself part of a joint project between our three organizations, FERA, FSE, and UNIME. This joint project is dubbed Strengthening Collective Bargaining for Audiovisual Creators. It's a 2-year project that I'm sure you remember a little bit about from our previous workshops and webinars. But for today, the focus will be the copyright directive transposition, and specifically sharing in the success of your work, collective solutions. The idea for today, for this second workshop, is really to focus in several steps into these different solutions to give you a bit of an overview of what exists across the European Union. We will start off with an overview of the transposition process in as much as transparency and remuneration is concerned. Then we will go into collective rights management with Cécile Desprang from SAA, and we will then move to a national case study after a break around 11:30, and then we'll have a moderated discussion with you all to reply any questions you may have on what you've heard, and discuss things a bit further if you find that useful. So I think without further ado, we can jump in and start with our, I was about to use some sort of a qualification for Ula, which I think I will keep to myself, but our dear friend and colleague, Ula Forgal, from, sorry, who was that? I did hear a sound, but that was not, okay, well, let's move on. Ula Forgal from Create at the University of Glasgow, who will take us through a bit of an update on the transposition process, specifically on the provisions that we are particularly interested in today. Ula, the floor is yours. Go ahead.
Thanks, Pauline, for an introduction. I do have a couple of slides to show you guys, so it's maybe easier. Okay, I hope that works. So good morning, everyone, once again. And today I'm going to take you through the implementation process with the focus on Chapter 3. So Chapter 3, as I think we all know of the Copyright Directive, focuses on creator contracts. And then here's most important provisions for us, at least today, or maybe in general, are those of Article 18, 19, and 20. So our principle of appropriate and proportionate remuneration, the transparency obligation, and the contract adjustment mechanism. So first, what is the status of implementation when it comes to Chapter 3? So nothing much changed in the last month. So the last time I was talking about it, as we all know, the deadline for implementation of the directive has already passed last year in June, but we are still maybe somewhere in the middle of the transposition process. I think the general hope is that the transposition process will finish by the end of 2020. However, it might be a bit optimistic seeing that not much of a movement happened in the last 4 months. So the status when it comes to Chapter 3 is that we have implementation finished in 10 member states, and the last change was Slovakian implementation that was adopted in February, and that came into force on the 25th of March. So this is like the newest implementation out there. On top of that, we have 4 drafts in the national parliaments, but we still have 4 member states that have not even tabled the drafts for implementations of Chapter 3. So again, we have Denmark, Poland, Latvia, and Greece. At least as far as I'm aware, those drafts have not been available to the public. But what is happening with particular provisions? So first, when it comes to our principle of appropriate and proportionate remuneration, most of the implementations that we have on the table do restate this principle, with one exception, or maybe there's a Czech speaker that will correct me, but as far as I'm aware, the Czech implementation does not actually state the principle of appropriate and proportionate remuneration. It provides for a mechanism to guarantee that, but it does not really state that as a principle. When it comes to defining what this appropriate and proportionate remuneration is, member states usually just restate a number of factors that should be taken under consideration. We're deciding whether a particular remuneration is appropriate and proportionate, and they follow the thread that we have in the recital 73, I think, of the directive. So there is this general account of principles that should be taken under consideration.
Can I interrupt you just for a second, Ula?
Yeah,
is it normal that the slides are not moving at all?
They are not moving?
Nope.
Okay, this is... Yeah, I don't know why sometimes that kind of happens, but...
I just thought maybe there was something there.
Okay, let's see. Does it work now?
Yeah, we're there.
Okay, that's
Great.
good. Thanks for letting me know.
Sure.
So when it comes to mechanism, I think you will discuss that in way more detail in the next parts of this webinar. But when it comes to what member states try to do with the mechanism, as the directive basically gives member states freedom to decide what sort of mechanism will be used to realize this principle of appropriate and proportionate remuneration. So unfortunately, a good bunch of member states is doing nothing. They're just saying that this is the principle and creators should receive this appropriate and proportionate remuneration. But if they are doing something, they are reaching for those collective solutions. So we have the common remuneration rules in Germany and in Austria. We have ministerial decisions on equitable remuneration in the Netherlands, or an option to have this decision, and professional agreements in France. When it comes to permissibility of the lump sum payments and whether they can be considered fair and they can be considered appropriate and proportionate, the directive says in here that it can be done in particular specific cases. Member states usually just restate that, so they don't really define what those particular cases can be. We have, however, a couple of exceptions. So for example, in Italy, lump sum is permitted only if contributions are of incidental nature. And in our recent implementation in Slovakia, we actually have a list of, still an open list, but there is a list of 6 situations where this remuneration can be a lump sum remuneration, can be considered fair. On top of that, we have a very interesting example when it comes to Estonia. So in Estonian implementation, we see that the implementation basically states that if no remuneration is being paid, or this remuneration that it's being paid is not appropriate and proportionate, this use should be considered copyright infringement. So this is a very interesting spin on implementation. But just to proceed, so when it comes to our second provision that interests us, so the transparency obligation, so basically an obligation to provide information on the use and on the remuneration generated thanks to the use of works and the remuneration due to creators. This transparency obligation is implemented, some member states implemented in a very detailed way. Some again, just make a general statement. What is quite interesting is that a format in which this information should be delivered to creators is very, very specified. And even if it's specified, we usually see that it's just a very general statement, or it should be delivered electronically, or it has to be delivered electronically, but nothing about how comprehensive this information should be, at least in general. When it comes to limitations to the amount of the information or that should be delivered to creators, usually we see a simple copy-paste of the text of the directive. So the fact that the amount of information delivered to creators in duly justified cases, because of the administrative burden it carries, can be limited, or where creators only make a non-significant contribution to the work, the amount of information delivered can be limited. But also just the general sort of restatement of principles, member states don't really go into details defining in which cases particularly. And something I think it's important is this aspect of confidentiality. So the directive basically states that parties should have this option of saying that information that is being disclosed as a part of the transparency obligation should be kept confidential. However, that should not affect their ability, creators' ability to use this information while exercising their rights. So the confidentiality of information during the implementation process is quite rarely addressed, and often if it's addressed, there is actually no guarantee that still information that is confidential can be used to exercise creators' rights. So this is a bit of a problem in the implementation process. And again, when it comes to like fun examples or quirky things to consider when it comes to implementation, an Italian implementation of the transparency obligation is quite interesting because it basically states that the information that is provided, or if information is provided not in the required extent or is not provided at all, we should assume that the remuneration that is paid to creators is inadequate. And in the case that a particular entity does not observe this transparency obligation, the communications authority in Italy has actually a power to impose a pecuniary administrative sanctions up to 1% of annual turnover. So this is quite interesting as an Italian approach to transparency obligations, because we have visible sanctions if this obligation is not observed by our contractual parties. And last but not least, when it comes to contract adjustment mechanism, what we see so far, seeing how the implementation looks like, is that we have, again, the restatement of the rights, that creators have the right to this additional remuneration in case we have this disproportion between what they received and the revenues that are being generated from the exploitation of works. But quite often we don't have a mechanism or we don't have a mechanism specified according to which creators should be able to use their rights. When it comes to what is considered as disproportionate, yet again, we have this approach of providing a set of factors that need to be taken under consideration when deciding what is disproportionate. So quite often there's types of revenues that we need to take under consideration, or what is the standard of the market at a given time. In general, we have common rules for all the types of remunerations when it comes to contract adjustment mechanism. But again, we have two fun examples of, for example, France that says that contract adjustment mechanism can be supplied only when I think this disproportion amounts to 7/12 of the revenue. So this is a very particular and I think quite important case. And something that unfortunately is happening with this contract adjustment mechanism during implementation is some of the member states limit in time the ability to use this mechanism, which I don't think it's a practice that should take place. So for example, in Slovakia, we can request adjustment to the contract only 3 years following publications. In Portugal, we can do it only within 2 years after finding out that there are circumstances that justify upping up our revenue. And in Spain, actually, we have a limitation only 10 years after concluding an agreement. So for example, if our works become super popular and starts making money after 10 years, we cannot use this mechanism anymore. So I think this was a broad overview and should give you a bit of a feeling what is happening with the implementation and what kind of quirks and different solutions out there are happening. So thank you very much for your attention.
Many thanks, Ula. That was really interesting. I find some of this particularly thought-provoking. The presumption that the remuneration is de facto not suitable in Italy is quite an interesting mirror to the presumption of transfer of rights to the producers, but whatever. Does anybody have any questions that they want to put to Ula at this stage? I think maybe that would help with the flow of conversation afterwards if we put some questions up right now. I'm looking up if I see any hands raised. Claude, go ahead, please. I think you are muted, possibly.
I was. Hello, my name is Claude. I'm the delegate from the Luxembourg Association of Directors and also scriptwriters. I just, because there is kind of breaking news, is that the directive, I mean the law implementing the directive has passed the Luxembourg Parliament just a few days ago. End of last week. So I didn't yet have the time to analyze this in detail, but it looks rather good at first view, since the articles that are relevant for us, 18 to 23, they seem to have taken over the wording from the directive. So it's really like a copy-paste from the propositions of the text of the directive. So it remains all in the general statement, and there are no really more concrete dispositions for implementation. But at least it seems that they have taken into account our preoccupations that we had concerning these articles, because we had a really strong communication on beforehand with the Ministry of Economy, since it's the Ministry of Economy who deals with intellectual property and copyright in Luxembourg. So we'll have a look at it in detail, but it looks rather positive.
That's very good news, Claude. Great. Indeed, I mean, yeah, sure, go ahead, Hula.
Yeah, can I just ask Claude about something? Because in Luxembourg, there was one provision that I think was a bit problematic. It was contract adjustment mechanism, actually, because the implementation didn't say disproportionate, but it said unreasonably low. And only then the remuneration could be adjusted. I don't know if this is translation thing, or if you could let me know if this is something that you guys looked into. That would be grand.
Yeah, I can try to find that right now. So if you give me just a couple of minutes.
Sure. Then we'll move to Agnieszka, maybe. Agnieszka, if you want to go ahead.
Yeah, thank you very much. Hey, Ula. You've given your email address and the other contacts with an Apple at the beginning. Does it mean that it's okay to get in touch with you to ask about some details?
Yeah, sure. Happy to answer if I can.
Yes, thank you very much, especially that Poland, you know, is in the position that we still have not been successful in implementing the directive.
Okay.
Thanks a lot. So I'm going to get in touch with you.
Thanks, Agnieszka. Hugh, go ahead. And maybe just introduce yourself briefly, since we have quite a number of participants and maybe some new people in. Thanks.
Certainly, I'm Hugh Farley. I'm the director of the Writers Guild of Ireland. Ula, thank you very much for the presentation. One thing that I'd like to, I guess, draw attention to is in the Irish transposition of the directive, it was done by statutory instrument and therefore limited in some respects as to things that could be mandated. But one of the things that we have found particularly troubling as we start to see lawyers for production companies trying to triangulate around the new regulations is to put in clauses that say that the author agrees with or asserts that the remuneration that they are being offered in the contract is currently fair and proportionate. And the problem is that the legislation doesn't make any provision for an adjustment of if there is such disproportionate power in terms of the relationship between producers and writers. If the producer says, well, I'll tell you, I'm offering you 200 euros to write this screenplay and every subsequent draft of this. And here's the contract that says that you assert that that is fair. The problem is that there doesn't seem to be any mechanism within Irish legislation, nor indeed within the original directive, to say that palpably that is not fair. There are vague definitions, as you say, when you get into the definitions for Article 18 of saying, taking in respect of market practices. So the problem then becomes for us is, well, what constitutes a market practice? If every lawyer in Dublin is offering this contract to production companies and they're getting writers or directors to sign them, they can say, I can show you 20 contracts, 30 contracts, 100 contracts where rightly or wrongly people have signed it. So that's clearly a market practice. And I think it's these things, the nitty gritty of how the legislation is enacted. You know, it's all very well to look at the transposition of individual articles, but you have to look at the practical workarounds. There's so many, certainly within the Irish statutory instrument, it's given so many hostages to fortune where a producer can assert it's a market practice, you know, and somehow excuse themselves, or for the fact that many production companies in Ireland are rather small operations. And so they could say, well, this transparency thing is, of course, we support it, but it's unreasonably onerous on us to produce accounts for every single production that we have produced in the last number of years, because I think Article 23 says that there's what is it, applicability in time? It's either 23 or 26. So
26, yeah.
Yeah. So they can very easily say, look, there's two people in our company. We can't possibly produce all of these accounts going back historically in time. We would do nothing else but do that. So thank you. That was the point I wanted to make.
Thanks, you. Ula, do you have a reaction, maybe?
Yeah, just to say that I do agree with the market practice that this is a bit of a problem, but it's always when, at least as far as I've seen in the implementations, when they do enumerate different factors, it's always a cumulative test, which means that even if something is according to the market practice, it does not mean it's fair. And even in Ireland, as far as I see, it's just one of the factors that need to be taken under consideration. And I know it doesn't kind of help you guys just signing your agreements, because unfortunately that requires a court case in the future that would say how we should assess that. But this is something that the legislation won't particularly help us to solve by itself. It's something that needs to be either more explained in the case law or in a particular collective agreement, but the legislation itself, I don't think it can even help.
Could I just jump in with a tiny other thing, which is about proportionality? So many Irish contracts are based on British standard industry contracts, which include an element of proportionality in the profitability. So very typically a writer might get 2.5% of the net profits of the producer. And that's already in and is a fairly well-established item of contracts that we would see. So the producer can argue there is proportionality. It says it in the contract. I'll point to the article. So what are you talking about? And so one thing that is somewhat, I don't know if that is the case throughout Europe. I'd be very interested in hearing for the rest of my colleagues. But for us, it kind of feels like, okay, then what are we actually arguing? If they can point and say, here's clause 22, and you're guaranteed 2.5% of the net profits of the producer, then you already get proportionality. So there is no further discussion, unless proportionality is not just limited to the producer share, but rather the overall commercial success of the project, in some external way that is not covered by that proportionality.
Mm. Anna is pointing out in the chat that this point that you're making, Hugh, is probably related to the difference between proportional and proportionate in terms of concept, and that sort of confusion at some point during the legislative process and within the translation in different languages throughout Europe afterwards that did not necessarily bring a lot of clarity. Anna, do you want to elaborate a little bit on that? I don't see you.
I think it's very, thank you. I think it's a very complicated thing to explain because, I mean, in Spanish it's very, very clear the difference because there are different words and both are of usual management. So proportional means a straight relation and a percentage between two different items. So if you are establishing that 10% of whatever is the amount that you're going to use, that 10% is a proportional amount, in relation to the big figure it's been applied to. Right. Whereas proportionate refers to an equivalent intensity, which means if you're getting paid 80,000 euros for the script of a movie, and the movie makes the average profit, that could be okay. That could be a market practice in a certain country. But then if that movie becomes a blockbuster and it makes like 3 times the amount that like the average movie would make, or 10 times or whatever, you're probably not going to claim 10 times the money you signed in the first place, but you're going to get some sort of proportionate increment regarding that the movie made 10 times the profit that is usual in the market. So, I don't know if that conveys more or less the difference between proportional and proportionate.
So just so I'm clear, what you're saying is that despite a contract which might give the writer 2.5% of the producer's net profits in ordinary circumstances, if that movie breaks out and becomes disproportionately successful, there should be an additional payment made to the writer above and beyond that original proportional contract provision.
That's correct. That's what we have already in place in Spain. That's why the implementation of the directive is being so disappointing in Spain, because it doesn't really give us any or hardly any of the advantages the directive opened the gates to. And that's what I think in Germany, they have the best-selling clause. And I think it's something in this line too. And yes, that's the way I would describe it, yeah.
I think, I don't know if our German colleagues want to come in at this point, but one of the important aspects in Germany is that we can enter into collective negotiations to define what proportionate/proportional means in practice with one market operator on behalf of the community of creators. That makes a massive difference in having common understanding, if not a legal definition of proportionality. Whichever way you want to understand it. I'm just looking if our colleagues want to, if anybody else wants to come in at this point. Not seeing anybody raising their hands. But in any case, I think that provides a bit of a segue to the rest of our program today, which is to look into existing collective solutions that are in place today and that we can look into. Thank you so much, Ula. I know that maybe you will drop out at some point during the morning. So many thanks for your input. And for those of you who do not know, Ula is indeed very precious to this project because she is the one who is looking into feeding the database, which we are currently building, to allow for us to see how the transposition of provisions relating to authors' remuneration in contracts is actually how things are going on across Europe, and how we can compare the different provisions that will end up being enshrined in national law. So she has a pretty unique vantage point in these issues, which makes her doubly important in our eyes. So thank you so much, Ula, and we will touch base with you very, very soon again, I'm sure.
Yeah, thank you very much, Pauline, for introduction and welcome.
Sure thing. Okay, so we will now move on to our next speaker, Cécile Desprins from SAA, who will take us through the process of implementing Article 18 through collective rights management, and basically take us through this notion of collective rights management as a collective solution. Cécile, I think I will leave it to you to introduce yourself in more details. I think you are quite a familiar face for a lot of us. But voila, without further ado, the floor is yours.
Thank you very much, Pauline, and hi to everybody. I recognize some familiar faces, but a lot are new to me. So because familiar faces, because I was in the same position as Pauline long time ago. So some of you were already active in the Directors Association. So now my position is Executive Director of the Society of Audiovisual Authors. And I will present you my assessment of the implementation of Article 18 in the EU member states. I will share my screen now and take you through this this journey that has started a year ago and that is not finished yet. So let me see how I move.
I think maybe you can go full screen and then, yep, that's it. Perfect.
And do you see slides moving?
Yes, yeah, absolutely. Great.
Okay, so this is my plan for today. I will present you a bit the Society of Audiovisual Authors, the rights managed by SA members, the collective management organization, few data on their collections. I will briefly introduce you to the existing rights to remuneration collectively managed in Europe. And then we will dig into the implementation of Article 18 to see if this directive is making any change on this aspect. So the Society of Audiovisual Authors grouped together 33 audiovisual authors CMOs in 25 countries. Together, they manage rights for more than 160,000 film and TV screenwriters and directors. You probably know that there is no unique model of collective management organization. So depending on the country, there are multi-repertoire societies grouping together authors from music, audiovisual, visual arts, book, etc. In other countries, you have screenwriters and audiovisual authors all together and separate from other repertoire. But you have all different kind of association of rights holders. So audiovisual authors are sometimes divided in screenwriters with other authors of written text and directors with other partners. Sometimes they are together with producers and or performers. So the landscape is very diverse. But we are all together in the SA to promote audiovisual authors' rights and remuneration and to give visibility to the collective management system in the audiovisual sector where, as you probably know, it's much less advanced than in the music sector. So that's our objective, to have more collective management in Europe. This is the table of the rights managed by ASA members. So it's very, as you can see, it's quite diversified. If we were in the music sector, it would be all red. So you see that depending on the country and on the society, it's a different picture. First category of collective management of rights is cable retransmission, thanks to the 1993 directive, which provided for mandatory collective management of the retransmission rights. Second, you can see in this table private copying. You know, it's an exception to copyright, but with a condition of compensation for rights holders. And then you have other retransmission right and online on-demand uses, which can be very specific depending on countries, not necessarily the big VOD platforms, and broadcasting. In terms of collections, this gives you an idea of the aggregated figures of the 33 SA members. So the first category, so together, SA members in 2020, they collected 703 million for audiovisual authors, euros, of course, music authors being excluded from this figure. So it's all audiovisual authors except composer of the music. As you can see, the most remunerative rights are broadcasting rights. They represented 36% of the total amount in 2020. Then you have private copying, but it was an exceptional year. In 2020, there were back payments in Germany. Usually, private copying is third, ranking third in our data. So in 2020, you had retransmission right third with 21% of members' combined collection. And you have this very small amount category for online on-demand rights. It's increasing year on year, but it still represents only 6% of members' collection. This is another way to present this data, where you have the category of other, which appear, and it usually covers public performance of audiovisual works and educational uses where there are schemes for compensation. To continue in the diverse picture, this is per country, the weight, the respective share of the main categories of royalties collected. So you can, in orange, it's retransmission. You can see that it's the basis of, in most countries, but not everywhere. For example, in Italy, there is no cable retransmission as such. You have in white private copying, in yellow broadcasting, and online, it's the very last category on top of each column. So let's describe the panorama of unwaivable rights to remuneration collectively managed in Europe. You have several laws which provide for a right to remuneration for audiovisual authors collectively managed. That's the case in Spain, in Italy, and in Estonia, with a general provision. In Poland, we have a list of rights that has to be collectively managed. So it's considered to be cinema, TV, public performance, retransmission, and rental. In the Netherlands, since 2015, if I remember correctly, sorry, it's quite recent, but there is a remuneration right for all communication to the public with the exclusion of on-demand uses. In Germany and Belgium, there is a very specific remuneration right for retransmission, because when the cable retransmission directive was implemented, even if it provides for mandatory collective management, because of the presumption of transfer of right to the producer, sometimes it was difficult for audiovisual authors to get a share of this money collected. So it was a long battle in the Netherlands. And so a retransmission right was planned in those countries, but in Germany and Belgium, it was specific for retransmission. And most recently in Switzerland, you have a new scheme for collective management of a remuneration right for on-demand uses. That was, I think, that entered into force last year. And then you have France, Belgium, and Switzerland, where you have a combination of a strong legal principle and a favorable environment for authors, combined with voluntary collective management practices on the model of the music sector. So it covers more or less the communication to the public. So what the directive, the implementation of the directive is changing in this landscape. So you know that the basis for possible change is Article 18 in the SAA, like with FERA and FSC. We fought hard to have this principle of proportionate and proportional remuneration, appropriate and proportionate remuneration, sorry. I'm sure you remember that this is a compromise. It was not what we asked for at the beginning. We wanted an unwaivable right to remuneration for audiovisual authors paid by users and collectively managed. We had the support of the European Parliament, but then in the trilogue negotiation with the Council and the Commission, the only compromise was possible was this new Article 18, because the audiovisual authors community and performers fought hard to have it. But as Ula already said, it leaves a lot of margin of maneuver to member states to implement it. And even if it says that member states shall be free to use different mechanisms, and we read it as if they have to provide for a mechanism to ensure this remuneration, the assessment of the situation is more I mean, most of the countries do not use it really. I just put here the recital 73 because it's not a very helpful recital in addition to what I already said. And some countries are implemented it also in a way to weaken the request for appropriate and proportionate remuneration. So as far as the implementation is concerned, my counting is a bit different from Ula, but I realized that I haven't not put Slovakia in it because I didn't have time to look at the text yet. But I've put Romania because I received the fresh news that Romania published its, adopted and published its law. And I have included Luxembourg also because it's in French and easy for me to check. So what is it, the way I've looked into all this implementation is for me to understand where the opportunity of the directive was used to improve the situation of audiovisual authors. And in this classification, what is important is to understand that there are a number of countries where there are already positive mechanisms for audiovisual authors. So my four categories are the countries with existing mechanism providing proportional remuneration to authors. So it's mainly the countries where I said there are unwaivable right to remuneration with collective management. Second category is unfortunately the biggest one and the less interesting one. So it's the countries with no pre-existing protection and doing the minimum requirements of the directive. Third category is countries taking the opportunity of the implementation to fix some problems. I would like this category increase in number of countries, but for now it's very limited. And my last category is about countries adopting an innovative approach. So I will explain you when I come to this. So let's start with the countries with existing remuneration mechanism and what the implementation is changing there. For the Netherlands, for now, it has not changed much. The legislature said that the notion of fair remuneration already existed in the copyright law, and they didn't challenge, which is positive, Article 45D, which provide for the right to remuneration with collective management for the communication to the public of audiovisual works. The only thing, if I'm correct, is that in a separate assessment of this new provision, so not linked to the implementation of the directive, because the Netherlands were the first to implement the directive, the legislature said that, or the government said that they would look into the exclusion of VOD platforms from this mechanism. If I don't have fresh news about that, but last time my member in Netherlands were saying that they were waiting for a consultation document on this issue to discuss the possible change of situation for video on demand services. But you know that the government changed in the middle of last year, and it took a lot of time for a new government to be in place. Second example is Italy. So here again, the implementation didn't change a lot as far as the remuneration right is concerned. They have changed the notion of eco compenso in Article 46 bis with compenso adequato e proportionato. So implementing the wording of the directive. So in practice, the Italian law does not formally require mandatory collective management, but that's the CIA is the collective management organization for authors, the only one in Italy, and they are collecting equitable remuneration right for audiovisual authors. With CISAC, the International Federation of Audiovisual, for collective management organization in all sectors, we are engaged in the writing of case studies to show the effectiveness of statutory remuneration right for audiovisual authors and the fact that it didn't have any negative effect on the development of the industry. We have done one on Italy. You have the link here, and it's on our website. We have done one on Spain too, and we are now developing one on Poland with the help of our member Zappa. France is a country where you would think, well, it's already done. They have one of the highest protection for audiovisual authors. And indeed, they haven't implemented the principle of proportional remuneration, which already existed in the law for authors, but they have implemented it for performers. And they took the opportunity of the implementation of the directive to fix some new challenges, I would say, in relation to the new domination of American streaming platforms in Europe, and to avoid that their good legal framework be circumvented by these new players. So they have provided that the proportional remuneration principle cannot be derogated by agreement. So it's to consider that it's a public order provision. No contrary provision is possible. They request collective professional agreement, but I'm sure you will talk about it later. I think what is the most interesting for here is that they have used also the implementation of the Audiovisual Media Services Directive to secure the remuneration in the access to subsidies by the film fund, and also for the works to be considered European as part of the quota. So if the contract, the production contract, do not respect the moral rights and right to proportional remuneration of the authors, they cannot be, they do not have access to the subsidies of the film fund, and they are excluded from the quotas of the European works. So that's an interesting combination of implementation with two directives to secure the impact of these new provisions. And I think it's interesting to note that music authors of audiovisual works requested a specific provision to ensure that they cannot be deprived of their proportional remuneration. And the mechanism they asked was to have to forbid the fact that their contract be subject to a foreign law, or even if the contract is subject to a foreign law, it cannot deprive them of their proportional remuneration. So you can see that for different categories of authors, you can have different views on what is necessary to fix your problem. Then very rapidly, Estonia. So I said that there is a general provision providing for a right to remuneration for audiovisual authors. So the implementation is very limited to introduce the concept of appropriate and proportionate remuneration. It doesn't say more in terms of implementation of Article 18. Then I come to the more disappointing category, the countries with no pre-existing protection and do not taking the opportunity to improve the protection of authors. Most of them just copy-paste the mandatory provision of the directive. So I can start quickly with Hungary. The legislators said that they already had proportionate remuneration concept in the law with their existing Article 16, but we know that it's a very weak principle today, and that didn't change. Malta, it's a very much copy-pasting of Article 18 and Recital 73. That's it. Ireland, a bit the same like Malta for me, copy-pasting Article 18 and 73, but even on Article 18, only taking the principle of appropriate and proportionate remuneration, nothing about a mechanism to implement it. Luxembourg, yeah, for me, Luxembourg law is really strange, because this provision about appropriate and proportional remuneration is in a section about exceptions to copyright. So it's very limited implementation, only the new provision in italic. Then this new category, countries fixing problem, maybe France could have been in this category, but I feel that France didn't have real problems to fix. But so in Romania, apparently there were problems to fix in the way the relationship with the collective management organization. So to my understanding, and it's very fresh because I didn't have a look at the text yet. So according to the information provided by our member, Dasin Sarah, they pushed to clarify that the money distributed by the CMOs for authors and performers should go to authors and performers, not producers, in spite of the presumption of transfer of rights to producers, because apparently this was a big discussion with producers and a big fight in Romania for a long time. So far, the solution proposed by Dasin Sarah was for authors to sign an annex to their contract to protect them about these royalties. But they were interested in having clarification in the law. So they are happy with this additional provision, which says that in addition to the remuneration provided by the contract, authors have the right to collect through their collective management organization the remuneration due for the real use of the work. And if there is no contradictory provision in the assignment contract, but it seems that they feel that it's this provision is securing the remuneration collected from CMOs to be distributed to authors and performers only. My last category for now, it's only Germany, but it might also be Belgium. So the innovative approach is for me the fact that in the implementation of Article 17 of the directive about the platforms, user-generated platforms like YouTube, you know that the directive provides for a licensing mechanism that is very elaborated to provide for licensing for these platforms and give a chance for remuneration for the authors and rights holders. Germany, to ensure that authors will get a share of this uses, even if we know that for audiovisual works, it's not the main exploitation media. But Germany provided an unwaivable right to remuneration with mandatory collective management for authors for the communication to the public of their works by the platforms. The specificity of German law is that it's not, this new provision is not in the copyright law, it's in the separate law that is implementing Article 17. And it was apparently a trick to avoid the Commission to complain about that, because the Commission considered that Article 17 of the directive is a fully fledged provision, fully harmonized, so you cannot add or withdraw anything from that. But from what I understand, Belgium is planning to have a similar unwaivable right to remuneration for authors with mandatory collective management for uses covered by Article 17 and also for uses covered by Article 15 about press publication. But the discussion in Parliament have not started yet in Belgium. And that's it for me. We have set up a resource page on our website where you can find recordings of events we have organized on Article 18, the studies and academic work that was made, for example, by Professor Xala Barder, and the case studies are referred to about Italy and Spain, and Poland is coming soon. That's it for me. Thank you for listening, and I'm available for any question.
Thank you, Cécile. I think yes. Let's open the floor to any questions if the participants have some. Giving a second to people to click, wave. Okay, I'm not seeing any movement for now. I actually have a question. So you've been describing basically national setups. One of the questions that we have to ask ourselves when we're looking into success-based remuneration has to do also with what happens beyond the borders of the country where the contracts was signed. So on this particular aspect, can you remind us a little bit about how cross-border revenue flow works in the collective rights management system, and how you approach this issue of the territorial mandate of CMOs versus the exploitation typically on global streaming platforms that can be just straight away worldwide. I think that might be interesting.
Okay, well, the territorial mandate of CMOs, if we are talking about rights to remuneration provided in the law, follows the same scope of the applicable law. So as long as we don't have a mechanism enshrined in European regulation that is enforced and applied, that can apply everywhere in Europe, we are limited to territorial boundaries. So the way collective management works is through reciprocal agreements between CMOs for the cross-border exploitation of their works. This is very common, and CMOs are very used to, they have a reciprocal agreement with a maximum of foreign societies. In the music sector, where it's purely voluntary, collective management it's very much developed, and because the panorama of rights managed is uniform, I would say it's easier. In the audiovisual sector, it's more difficult, but if you have equivalent rights in between countries, you can expect to have to receive royalties for the foreign exploitation of your works. But it depends very much on what the law provides in the other country. And if you have collective management organization in those countries. So I would say, for example, if we take the example of on-demand exploitation, if I understand correctly, or for broadcasting, the countries who have this kind of collections, the CMOs who have this kind of collection, they exchange, they are all in a network and can receive money for the exploitation of their works in those countries. For example, let's say Italy, Spain, France, Belgium, Poland, just to name a few. Retransmission, it's much more developed because you have this mandatory collective management. So it's, I would say it's the first foreign royalties that audiovisual authors get from their CMOs usually, because it's more developed.
It's also quite a contrast in terms of implementation of a European, well, not directive, but a European legislation, that if you have an harmonized implementation through an instrument that is very strong, it's obviously making things easier than what we're seeing here with the directive, where the transposition is quite fragmented and not interpreted in the same way in different countries. Bert, you have your hand raised. The floor is yours. Go ahead for your question.
Yeah, even before the directive, we, from personal experience, we were already running into problems with cross-border collection between Netherlands and Belgium, because there is no harmonization. There's no equivalent transfer of rights, well, according to the respective CMOs, at least. So a lot of money, which we as writers feel is owed to us, stays in Belgium, and it's almost we're running into a wall. We've been doing that for years now. So even before the directive, this cross-border collection is a huge problem, in my experience. I just wanted to make a note of that.
Yeah, if I can, yeah, I think there has been a lot of problems in Netherlands and in Belgium. I have the feeling that Belgian people feel the same about the Netherlands. So there is an issue there, and for many years in the Netherlands, there were no collection for foreign authors. But it was also a problem for national authors. So from what I understand, for retransmission, for example, there were lots of court cases, litigation in the Netherlands to get the cable operators to pay to CMOs.
But there was within the Netherlands itself, which was a very long court battle. But that's not exactly what I'm referring to. It's
no, I understand
the cross-border aspect, and we're doing.
But
fine,
it means that foreign authors
with
were
Italy.
not paid neither. It was the same for foreign.
We seem to be doing fine with Italy and Poland, and but it's kind of remarkable because part of Belgium, it's the same language territory, so to speak. So it's and we do on our end we do seem to be paying the Belgium authors exactly what we would pay a Dutch author in the Netherlands, which is as it should be. But this is just a very particular personal thing, but I'm just saying it's harmonization would be a good thing.
Yeah, I think that's kind of what's interesting about these cases where you see difficulties in bilateral agreements, that there is probably a number of solutions that can be found if you have a higher level of harmonization, either in law or at least in the framework of operation between the two countries, in as much as authors' rights are concerned. Does anyone else want to raise a question at this point? Comment? Anything? I'm looking for waves, hands raised, or anything. Nope. Well, I think it seems to me like we have run our course on this topic for now. I would like to suggest, since we're a little bit early in the agenda, but nonetheless, in order to take a little bit of a breathing time before the case studies, to take a bit of a break. We earmarked initially 15 minutes. So if that works for you guys, I would suggest that everybody connects again at 11:30 on the dot, and we will be back live at that point. Thank you so much. See you then. Hello again, everyone. Giving a couple of seconds for people to log back in after a well-deserved break. And I'm realizing that I have so many things that are gonna start beeping wildly in a second. Up, stop it. Yes. Okay. All right. Okay. Well, I think we can start the ball rolling for the second part of our webinar this morning. Thank you so much for being back. I'm going to start with a warm thanks to Cécile for her very detailed presentation and for playing the game of going back through the different aspects of collective rights management and how it relates to this work of transposing the copyright directive. I know that some of you were asking about slides to be communicated. I think we will, of course, ask Cécile and Ula if that's okay, but it seems to me like I see a thumb up. So thank you very much for that. And now we will move to the second part of our little tour of collective solutions existing out there. And the second category, sorry, I've been distracted by a message. So the second category of collective solutions that we are looking at this morning are collective agreements. And we know that there is a very wide variety of frameworks, both on the legal side and in terms of collective negotiation practice in different member states. So we tried to select a few examples of what exists out there and to get these to be presented to you in the shape of case studies. We will have 1, 2, 3, 4 of these if all goes well. And the idea is that we let our speakers start with an introduction and a description of the collective agreements that they have and that they are practicing. And then we will open a moderated discussion after. Of course, if there are burning questions in between, we will allow for it. But maybe for the flow of discussion, it would be good to keep a conversation and a more open discussion for after the presentations. And without further ado, we will start with you, Marcel, from the Netherlands. And I will not go into any details. I think it would be great if you could just introduce yourself in a couple of words and then take us through the interprofessional agreements that you have in the Netherlands. The floor is yours.
Yes, thank you. I'm Marcel Fokking from the legal staff of the Authors Union in the Netherlands, of which the network Screenwriters is a part. Today I'm going to talk about a few measures, and I'm specifically asked to zoom in on the topic of video on demand. So that's where I'm going to focus on the mostly and at the end. And I saw Olga Meijer from the Dutch Directors Guild is also present. And I think she knows a lot more about VOD than I do. So I asked her to chime in if she has anything to add or correct. Well, as bespoken before, in the Netherlands, there already have been some options in place regarding fair remunerations since 2015. But by the way, I don't have a presentation, but if people want this in some kind of presentation format afterwards, I can still make one, which might be useful. Well, like I said, there have been some options for fair remuneration in place since 2015, such as the possibility for additional fair remuneration and the possibility to offer a collective bargaining agreement to the minister for approval. We already saw that also in one of the earlier presentations today. We also have a dispute resolutions committee for authors contract law in place, and an article that allows authors to revocate their rights in case of non-use. And all this legislation has been evaluated in 2020. So we're now basically in the process of, well, seeing what kind of improvements are possible to the legislation that is already in place. The dispute resolution for committees, the dispute resolution committee for authors contract law. We have a committee in place, but so far there only has been one case, well, officially two cases, but regarding the same movie, which was very successful. So this was about additional fair remuneration. And you spoke about it a bit earlier about an additional percentage in case a movie is very successful. Well, that was also what the committee decided, that the director and the screenwriter both had a percentage of the money that was being generated. But because it was so successful, they needed an additional percentage. But unfortunately, it's not mandatory for anyone to go to this committee. So this is the only case since 2015 present up to date. So we are currently looking whether it's possible to stretch a definition of what constitutes a dispute. So it's, for example, possible for associations to let the commission assess or review contractual clauses that might be unreasonable. Because of course, for individual authors, it can be a huge step to go to court. Or even to a committee, but if a organization, a more collective organization is also enabled to step to this committee, it can mean a lot for individual authors that don't have to fear blacklisting, for example. And it also will make it easier to step to this commission to begin with. As we've spoken about before, that it's also possible to offer a collective agreement to the minister for approval, but this is only possible if both parties agree, and it can of course be hard for example screenwriters and producers to come to an agreement, especially there's no need for the producers to come to an agreement. So we're also seeing whether it's possible to offer a one-sided agreement to the minister for approval if it's possible to demonstrate that you made a real attempt to get the other party to the table, but they just keep refusing. Not only so it's possible to offer a one-sided agreement to the minister, but also to have a tool to force the other party to the table, because if they don't, it's of course possible that a one-sided agreement is offered and they have nothing, they haven't brought in anything from their side. When discussing remuneration, it's also possible to make the distinction between a maker's fee on one hand for the time and effort that has been invested in the creation of the work, and on the other side, a remuneration for the exploitational value of the work. But in most of the legislation, it's only focused on the remuneration for the component that you give permission for the use of your work and the exploitational value of it. So the maker's fee component is not involved. For example, if you want to offer a collective agreement to the minister, this must be about the exploitational value, and it does not cover the maker's fee component. So this is something that is being discussed, whether it's possible to improve on this. And also whether it's possible to make to introduce an obligation to substantiate a difference between the maker's fee component and the exploitational value component in the work, so that both elements have to be present and substantiated when a contract is being written. Now I'm stepping to the VOD part. We have a system of voluntary collective management. We're not happy how that turns out currently. So first I'm going to talk about what we have, and then I'm going to talk about how we're currently working on changing it. We already saw in the presentation of Cecile that the exception for when it comes to unwaivable rights to remuneration collectively managed, there is an exception for video on demand, and that's where the problem is centered. For example, for cable exploitation in the Netherlands, we have mandatory collective management. That means that the collective companies pay to the collective management organizations, and in return, they are allowed to broadcast copyright protected content without requiring permission from the copyright holder. So for individual authors, it's not possible to bargain with the cable companies about the remuneration they receive. It's all being done collectively. And currently for VOD, there is a system in place that makes collective management possible on a voluntary basis, but not a mandatory one. The legislator naively assumed that the makers would be able to bargain, that they would have enough bargaining power to negotiate terms with, in first instance, with their producers regarding payment for exploitation via VOD, and that they in turn would be able to negotiate with the video on demand platforms such as Netflix. The problem here is, of course, the Dutch screenwriters don't have a strong bargaining position, and that has also to do with a specific legal clause regarding film works, because the Dutch Copyright Act assumes that the maker, when it comes to a film work, transfers his exploitation rights to the producer. Of course, the bargaining position of every author is weak, but the screenwriter's position and other movie maker authors are weaker from the get-go, because it's assumed that they already transferred their exploitation rights unless they agreed upon something else. But of course, there's, well, that also makes that for producers, it's not even really necessary to explicitly arrange something about the transfer of rights, because it's assumed that they already have the right to exploit works. Well, the conclusion is that in many occasions, it's not possible for individual authors to make arrangements for video on demand, which of course would still be possible under the voluntary collective management. So it would be better for them if the compensation for use of video on demand could be negotiated for and in by a collective management organization. Through the years, after many negotiations, parties managed to agree upon the system of voluntary management. As I said, I'm going to go a little deeper into how that's currently given form. The parties, by the way, are an organization that unites producers, broadcasters, and distributors. That's one side, and the other side is a platform for audiovisual creators, and they work together with the CMOs to on the side of the authors to negotiate the fees. Well, the system in place is as follows. At first, the author has to agree with the producer to manage the video on demand remuneration collectively. That's being done with a clause in the contract and an addendum with additional terms regarding this video on demand regulation. And in this clause and addendum, they also agree that the producer has to impose this later on the exploitational parties, such as the streamers. And of course, this also has to be actually done, because only thereafter it's possible to let the collective bargaining management organization collect the money and pay it out to the authors. So at first they have to agree with the producer. The producer also has to agree these terms with the video on demand platform. And if it's not both being done, the author gets nothing. And of course, it can also be hard for a producer to negotiate this with a streaming platform, for example, because if they just refuse, the author is still empty-handed. And it's also a cumbersome process. The streamer can, as I said, not agree. And it's also hard for the CMO to negotiate a good remuneration because up to now, the streamers have barely paid up anything if they pay up at all. So currently we're having basically a discussion whether it should be mandatory or not. There is a consultation for the amendment of the Dutch Copyright Act to make this collective management mandatory. But we also have seen that there is a strong lobby from the producers and distributors against this mandatory legislation. They pretend that this makes negotiations on the terms, because of course the first step is making it mandatory, but the second question is still what the remunerations should be. So that should be still negotiated about. And they are saying that it makes the negotiations harder, although both parties have been negotiating for 13 years already now. So it's not like we have any good results we can show that actually prove it would be harder. It's just something they say. The producers and streamers also really pretend that they want to pay because it's so important. But if they wanted to pay so badly, they could have been paying now on a voluntary basis, but they don't. And we also know from experience that as soon as there was any question at the side of the cable exploiters about whether they had to pay for something, they simply stopped paying, and we had to step to court to force them to pay. So mandatory legislation can be very helpful to make sure that to make it clear that they really have to pay for something, and making it explicit. Another argument they have is that if they have to pay much more than they pay now, that they won't be able to invest this money in producing more content. So they pretend it's also in the best interest of the authors not to have this legislation, this mandatory legislation in place, because then they won't be able to produce more content and there won't be any more projects for them to work on. And that's their conclusion is, yeah, you really have to just keep negotiating with us. It's really in your best interest as well, and we really want to come to an agreement. But as I stated before, it has been able to come to an agreement for 13 years now. And another point they make is, well, Pauline already mentioned this in response to Cecile, and Bert responded to it as well. When it comes to the cross-border workings, they also say, well, if collective management is legally mandatory, it automatically gives a claim to CMOs across the EU on money that's being collectively inned because of the EU's non-discrimination legislation. So, for example, if we collect a huge amount of money, only 10% of that money is going to Dutch creators and everything else is going to foreign countries. So they're really steering the fears that there's not going to be any money left. But as stated before, it's not really like they're paying a lot now. So it might be a large improvement anyway. So the current state of events is that a consultation regarding the legislation has been opened now. So we are now preparing with different organizations to give input, but also the idea we have with the network screenwriters is to maybe zoom in on different elements, but at least make sure that we're not all using the exact same copy-pasted words. So it's really different voices all working towards the same goal. This was my what I had to say. Hopefully my English wasn't too bad.
No, it was really good.
If there are any questions, I'm very welcome to answer them.
Thanks, Marcel. That was very interesting. Olga, do you want to complement with anything or not particularly?
Well, I want to stress that our counterparties, the producers, the broadcasters, and the distributors, well, it's a hard word, they have their main argument is the leakage argument. They state that if we have to pay mandatory to the CMOs, we won't be able to exclude American right holders. And all the money we pay will be distributed to American right holders. So that's the leakage argument. And they also refer to RAP PPI judgment, of course. And, you know, they make it very, very complicated. While in fact, we have mandatory collective management in place for BMS. That's the making available of the communication to the public right. And the American right holders did not claim for that. So we think that risk is manageable.
Okay. Okay, that's interesting. Does anyone have any burning questions? I don't see any hand raised or anything waving, so I would say no. Just to summarize in a shamefully short sentence, would it be fair to say that basically at some point there was in the Dutch legislation the possibility of collective negotiations, but the fact that it was not binding basically made it pretty much void in terms of ability to secure an agreement beyond the negotiation process, and that it kind of pushed you towards a collective rights management solution on a mandatory basis, because at least that is something that would be secure. So you went through the motions of trying to get the collective bargaining solution in place, but the fact that it was not binding pushed you back towards a CRM solution. I see you nodding. Okay. All right. Yes. Okay, then that's well understood. I think if there are no burning questions, we will move to our French speaker. Barbara, you are up. If you can introduce yourself in a couple of sentences and then bring us to the goal of what's happening in terms of collective bargaining in France.
Yeah, thank you, Pauline. So hi, everyone. I'm Barbara Lesclos from the Documentaries Directors Guild. And well, perhaps first we'll thank Céline for her presentation too. And I will not come back to the agreement regarding standard contractual clauses that because she already talked about it. So I will focus on the ongoing negotiations. I'll try to, well, perhaps focus on 3 points that everyone can follow what I'm saying, because I don't have a presentation either. So first, the legal context in which these negotiations are taking place. And then the different stakeholders, though concretely, you know, like concretely who is around the table, and then our goals as authors or documentaries author representative, and the main obstacles we are facing. So perhaps first, as for the legal context, it should be kept in mind that the main provisions of the directive concerning authors were transposed international law by referring to collective bargaining. And in France, we had professional agreements in place prior to the directive, which aim to ensure the transparency of revenues generated by the exploitation of works, for example. And but however, the directive goes further than these agreements, but the negotiations are therefore a bit delicate, because we need to articulate the existing agreements with the directive and the opportunities that the directive opens for us. Then, as my second point, perhaps on the different stakeholders in these negotiations, for the moment, on our side in documentaries, I'm not talking for, because it might be different for other genre, like in fiction, it's not the same for everyone, and the negotiations are segmented, so I will not, I can only talk for documentaries. Negotiations have been launched between the authors' representative unions and CMOs. It's important, we are both in it, and representative of the producers. And on the, so now we are on the question of appropriate and proportionate remuneration. For now, it's the question we are discussing. We are only on fair remuneration right now, but we also ask for the presence of the Ministry of Culture and the CNC, the National Film Center. So why do we want the institutions to be there? But this might seem strange to some of us, perhaps, because it really depends on national context. But in the French transposition text, one of the transposition text, the ordinance of May 2021, this ordinance provides that if no agreement is reached, the ministry may issue a decree to set these provisions. And we, if government decides to intervene, it will say that we failed in the collective bargaining process, and the decree might depend on lobbying capacities of each stakeholders and political will, and this could prove to be very disadvantageous for authors, perhaps because our lobbying capacities are perhaps not the strongest. And we are also going to change government in May because there is presidential election. So there's a lot of uncertainties for us. And that's why we have an interest in negotiating. And so as we are trying to set this negotiation up in such a tight schedule, I would say, we requested the presence of this institution as observers of the negotiations, which they accepted. So just to perhaps sum up this point, these negotiations means like working closely with authors organizations, including CMOs, building a dialogue with producers, which is not a given, and ensure that public authorities take responsibility of like ensuring that these negotiations are properly conducted. And perhaps now my last point, but I think the most important after this context, our goals and the main obstacles we are facing. So first, we are trying to prove that the directive goes further than the agreements already concluded, and that these agreements must be reconsidered. And so it's important necessary to seize the opportunity opened by the directive to go further than the existing measures, which are not always effective. And that's why it's important, because we had time to measure that some of the things that were in the agreement doesn't really work as we want them to work. So that's also an opportunity to take. And so there is, I would say perhaps, the first obstacles, the issue of the possible contradiction with competition law, which has been raised by our partners, and we should be resolved thanks to the European Commission's guideline. Well, we have already discussed this subject at previous FERA webinars, so I will not go over it again, but I take this opportunity to thank Pauline for your help on this point. And perhaps go to second obstacles in negotiating the minimum rates percentage to assure that there is a proportionate and appropriate remuneration. Because now, like currently, we have proportionality in our contracts, like in Ireland, as you explained before, but due to a lack of transparency, authors do not always receive the exploitation reports of their films from the producers. So even if an interesting percentage is included in the contract, they do not have the means to know whether the film has generated income, part of which should be theirs. So there is really like an interesting remuneration that could be negotiated, will be useless if there is no transparency with it. And this is what we are already facing in France. And second point could be that also the presence of a high advanced payment in the contract instead of a true remuneration for the writing also neutralizes the benefit of an interesting percentage, since the producer is reimbursed for this advance before any payback to the authors. So here again, the issue of transparency is like telescoped with the issue of fair remuneration, since the amortization of the film is an information that is not always shared by the producers, even though it's a trigger for payments to authors. So that is why the question of remuneration cannot be settled without being dealt with, like in parallel, if we don't deal with the question of transparency, that we don't, we need to keep in mind like the big picture of all the whole system we are creating in these negotiations. So just perhaps to sum up, we are not trying to use these new negotiations to address also to fill in the gap we see in the implementation of the existing agreements, and this is a long ongoing process, and it's not always easy, but we're trying to. Thank you.
Thanks, Barbara. Does anybody have any questions for Barbara at this point? I'm not seeing anything moving for now. So listening to you, I'm thinking, by contrast to what our Dutch colleague described before, you do have in legislation a form of binding process for these agreements, because there is a bit of a time limit, and if you don't get to a point where you can agree with your negotiating partners, then you end up with a decree. So you have to mind, as representative organizations, on the first format of negotiation, your negotiating power, and then after that, your lobby power, should the decree become the format that results. So in both cases, there is a sort of a structural challenge to your operation, as I hear. And of course, the French context being already heavily regulated and agreed upon through various ways. And so you have a bit of a layer cake effect that you have to deal with in terms of priorities and where some rights may not be valued properly, where you can intervene and with what kind of tool, because you do have collective rights management for certain things, and then collective negotiation and interprofessional agreements for other things, and how you articulate everything becomes quite complex from what you're saying. Can I ask you, so when you're talking about these collective bargaining negotiations on proportionate remuneration, does that have a scope which is exploitation beyond the French territory?
Well, it's yes, because
all exploitation.
It's all exploitation because in the for French territory, it's already in like it's the CMOs are already doing everything, and but all the fair remuneration that we can negotiate here, it's for other exploitation overseas, where the CMOs are not there.
Right.
And this is really the gap, because for territories where the CMOs have agreement, it's more or less working, but it's really for when it's when the instance the film is I don't know, in Japan, for instance, most of the time the authors don't see any return from this in this kind of country.
Right. So it's patchwork and layer cake, and then you deal with that whichever way you can. That's yes. Quite a challenge.
As a lot of things are already in all the agreements we have, one of the first question for everything is, oh well, it's already in the agreements. We don't need to discuss that. And the first thing every time is, yes, we need to discuss that because the directive goes further and we have a chance to make it more efficient. But it's the first things to discuss every time. And so that's really, it's complicated because at first, on one side, we can say that having all of these agreements is already, it's a good thing. We're not starting from nowhere, but at the same time, it can also be used as like a stop to any discussions.
All right, that's a point well made, I think. Okay, well, if there are no burning questions, and I'm not seeing any, let's thank you so much, Barbara. We'll move to our next speakers from Germany, and I believe that's Peter Henning, who is now with us. Peter,
I'm here. Hi.
Hi. I'll let you introduce yourself and take us through the format of collective agreements you have in Germany. Thanks.
Yes, so I'm a member of the board of the VDD, German Screenwriters Guild, and I'm negotiating with everybody in Germany nowadays, actually, with the public broadcasters, and we have a lot of joint remuneration agreements over the years. And actually, we also working on an agreement with Netflix, so which is quite complicated, as you might understand, because it's a big change. So I don't know how much everybody of you knows about history and what our main problems are. So I like to say some words about history, where we came from, and what's the challenge of the new times for us. So history is that in public TV, every use has been compensated in the old days, the good old days we call it, because you got 100% if a film you have written had been shown on public TV in prime time again. So you had a special amount of money. So let's say if you had a somehow normally success, you got in the end something like 90,000 overall in the end out of writing one screenplay. So you got a special amount of money for writing, and then you got the main money afterwards for the use in public broadcast. So And then and the amount of money which you got from broadcasting was related to the potential public station could reach. So if it was just regional, it was less money, 20% of your first income, and so on. And it was quite a good situation. But naturally, not every film was so successful that it had been reused. So, and on the other hand, we got lots of more programs in the market from one public TV station, ARD especially. They had more channels, more and more channels. And then on the other hand, all the regional broadcasting stations got to broadcast nationwide. So the audience grew, but also you were just compensated for the original reach from the regional ID station. So this and for this they had a much bigger need having some program. So they had a greater need for program with the same amount of money they had to pay the writers for their work. So they tried to compensate this with a local buyout system. Total buyout systems, because not every film had been broadcasted. The authors made a kind of an historic failure in Germany. They underestimated the effect of that, because after a while they used to just broadcast the buyout programs. So the more they had in buyout finance programs, the less they used the ones who have been paid for every use. So. But then we had a change in the author's right. So we had this best-selling paragraph, which was started to become somehow a powerful instrument for the authors. But on the other hand, there was also again a problem. How do you find out the amount of use? So, and all the people, broadcast and everybody else, didn't want to give us the numbers. So we had to fight injustice for court, go to court to make them change that. And this also led to a change that now we got a right of profounding information. So in the author's right, it also has been a change. So you can see this have been the last 20 years of a fight, very strange, complicated fight. It was always trying to get the politics to make a change in author's rights and also try to negotiate something. So because of this best-selling paragraph and this right of providing information, there was a lot of pressure, and there were some people, as you may have known, Das Boot, the legendary fight before court from DOP of this thing for his rights. He won in the end. It was not so much money he expected, but in principle he won. So also the private TV stations now had the problem that they had used such an amount of program without paying any more for this. So, and they were now sued, and they had to pay a lot of money back to the authors afterwards. So, and it was a huge problem for them. So, but they were quite open to negotiate. And before this, also the public broadcasters didn't want to negotiate with authors just individually. There was no joint remuneration agreement. But with this problem they were really interested in to getting a kind of agreement to be safe. Because of this, they could handle out the different systems, how every use has to be counted, how much money they had to pay in advance for so much use, and so on. And this is why we came into the play and were able to, in the last 10 years, to get one agreement after the other. So this is a historic situation, and it's not quite satisfying. It's always a huge fight about minimum compensation and everything you want to have with all the people, because they naturally always say, we don't have so much money, and we would have to reduce programs, so this is bad for you. And it's all the arguments, I guess. So And now, then the internet came, so which is quite different again. So for German television, the internet is not really working. So because there's not such a great use of public TV station program at the moment. It's the traditional use in public TV is much bigger than the one in the internet. So we get not really a lot of money. So, but we were just trying to implement more and more a kind of a system. So what we want to have in the end is also that every reach uses, which means every click, every single use should be paid somehow. So. But this is also quite complicated because now everybody wants some of this money. So the DOPs, editing people, nearly everybody wants a bit of this money. So what the stations try to do now is to find systems where they have a special amount of money, which they to do in a kind of a pot, and everybody and the people. We all together have to figure out how much every department's gonna get out of this. So if you have, for example, an actor and he's getting, I don't know, 5% of this pot, it's nice to have for him because it's not his system how he got paid. But for screenwriting, it has always been the problem that you have all the development usually for us is not paid. So we are always paid in advance. So we got an idea, we write it down, we have to bring it to a station and ask for money for writing a screenplay. And the main money we get in the end when the film has been produced and is getting to be broadcasted. So then we get also a special amount of money. Half of the money is coming when the film has been broadcasted the first time. So for us, it's quite a different situation. For us, all these remuneration money is very important because it's developing money for kind of a new script. So it's a rhythm how we work. So we get some money for a piece had been broadcasted, which could have been 30,000 euro or something like this. And this gives me the freedom, for example, to write something new. So. And with this buyout system and everything, this whole system broke down. So there was not so much development money because in old days, also broadcasting stations said, so I don't have the money this year in my budget to give you a screenplay contract to write a screenplay. But they said, okay, I broadcast a film you have written. So you will have this kind of money, and for this you can write it on spec and I will buy it next year when I got the money. So this was a kind of a system which worked quite good somehow. It was a little bit different. So but now with this total buyout thing, and also Netflix and everybody used to work on total buyout, so you get quite a good money as a kind of minimum compensation at the moment. Let's say if you write one episode in a season, I think mainly it's paid something around 40,000 at the moment. It's nearly everybody or most people get this kind of money for writing the episode. It's not about creating the show or whatever, just about writing an episode. But if there's a huge success, and we had some in Germany, for example, for Netflix, some really huge amount of reach. So with the first season, immediately in the first weeks, 30 million people worldwide. So it's really a big change in reach of audience. So, but it's not enough money for this in the end. So and because of the author's right, Netflix now is also forced somehow to make a joint remuneration agreement with the authors. To be safe with the best-selling paragraph. So they are not really interested in telling us about their numbers. So they don't want everybody to know which kind of program has reached which kind of audience. So they just speak about big successes, and they don't want to speak about failures, for example. So they are have also a problem with this thing providing information. So they somehow have to provide information for your product, but they don't want to provide information at all for everybody. So they don't like the transparency of this kind of things. So these are the 2 points why they are negotiating. But this is also something bad which happened in Germany. There had been a contract with the actors and with Verdi, which is a guild, but they are not able to negotiate for writers because the VDD has an exclusive right to do this in Germany. But they did an agreement which has set up a system which is called the completer model. I don't know if everybody of you knows what this means. I think most people know it in between. This means if you get an amount of use, which means 10 million completer, and you would get a special pot for the German, every German right holder. This is the system they created with this 2 organizations and made a joint remuneration agreement. But this again was a problem because our part of the pot would have been much too low. So we need much more money for this because of the special situation I told you before, because we need somehow have to earn something out of a success to write something new. And so it's very important for our financing system in writing. So, and this is a huge problem because Netflix wants very aggressively this system being set in whole of Europe. So there are some guilds who accepted it at the moment, some do not, because we all think it's a strange kind of a model, because completer means somebody has to see this whole season completely. So to 90% of this program had to be seen this. But we have been used, if I wrote an episode for a German series, for example, I would get always money if this episode is going to be used and not just if the whole season has been seen. So this is a quite strange kind of system, what has been set up by Netflix now, which I think for them is comfortable because they just are sure to have no problems with the best-selling thing because they pay the best-selling thing. But on the other hand, there in between there's a huge use we can't control, which will not be paid. So and this again makes a problem. How much money should they have to pay in advance? So this is where we are now negotiating. But because they want this completer model established for everybody to be safe, they just agreed to kind of compensating by a bonus system. So what we're now negotiating, we are not ready now. We are in the middle of negotiations. Very complicated. I don't know if we'll come to an agreement. We will meet in April the next time, but there are many small problems. But what they now offer is a kind of a bonus system, which means you always get a bonus if they draft a new season, for example. And every author of the last season before, which created somehow the success, we're getting a special amount of money. So I can't talk about numbers now because we are in a negotiation. So as you know, I can't go too specific into details, but we are trying to set up a system where you get kind of a launch bonus. So if it's has the series episode has been launched the first time on Netflix, or the whole not just the episode, the whole season has been launched, we get a kind of a bonus if it's relaunched and so on. There's a whole system of this kind of bonus paying. It's not the best thing to have. We would like more or less to get the numbers and then get paid from the first click, from the first use. on, but Netflix is very strict in this. They don't want to have this. We also want, our main argument also is, if there is a program on a platform, this is also worth a kind of money. So it's something what they have in the States, the Writers Guilds, that they get money for every year. It's just on the platform. So we also wanted to have some kind of this money, not the same system, because it's what in the States the writers, they get every year money for having a program on the platform, but they don't get this best-selling money. So it's a bit complicated to find a quite good relation between best-selling, because we want this also, and also we wanted to have a kind of a fee for fulfilling the program of a platform. So, but they don't agree to this, because they just want to be sure with the author's right, and I don't want us to be somehow comparable to the American market. As we all know, they get a lot more money out of being on the platform programmed for a year than we would get out of a best-selling paragraph. So best-selling is good for the very successful shows. They can get a lot of money in the end. It would be quite good. But if you have a season and that's it, or you have a mini series from 6 episodes, you won't get so much money out of it in the end. So I don't know how detailed I should refer now to those things. If you have any question, maybe to this might be more useful than me trying to.
Right. I think maybe one thing that could be useful is, before I pass the floor to Olga, is just to remind us how joint remuneration agreements are structured in Germany. So you have legislation which builds the concept, and then you, as a representative organization, can go to companies, broadcasters, users of the work, Netflix, whomever, and then you have to go through the motions of defining a number of concepts, which sometimes puts you as representative for screenwriters in a bit of a difficult situation, because you have to mind how authors' rights reflect, how their valuation reflects the necessity of your workflow, which is not the same as other categories of authors. Did I get that right?
Yes.
Okay.
Definitely, it's also a problem, because old writers like myself, we got used to this very comfortable system in the past. So when it's changing, it's sometimes for the not so successful authors, it's much better now. Right. Because they always get more money than they got before. So what we always have to think about is, because we have all kind of members, very successful members, and on the other end, people who don't get so much money out of writing. So what we also try to do is lift up the lower end, because my negotiating power individually is much stronger, for example, than lots of writers who are writing other kind of programs, for example. So, and this is also always a big discussion between all the members. You can imagine there are some people who are very influential because they are successful. They say, "Oh, I always got much more money," and they don't know that the other guys would really like to get some more of this money. So it's a complicated situation for us in between all those ideas and people. And on the other hand, everybody is very strictly negotiating. It's not a pleasure anymore. There were some years where they really needed something from us, but now they get it, a kind of a ground understanding of this. And there have been some quite useful things, compromises have been found between public broadcasts. But now with this new situation with the internet, everybody tries to define it how they want to define it, and not how we think it's a fair use. So it's very complicated at the moment.
Yeah, you're being confronted, as I think everybody is, in trying to make authors' rights and their valuation reflect the needs of your profession.
Yes.
The people in front of you are just managing costs in a business model, which is quite different from the operators that we've known in the past. Olga, you have your hand raised.
I would say something too. What we also do, if we try to be very creative in some kinds of new compensations. So what we, for example, we want to have in our joint agreements a special amount of money every year from a broadcaster for development, which has been quite new. So they now have to pay you for your development when you start to research things or something like this. There's a special amount fixed they have to spend every year, and we got also kind of a success system. So every time you get a prize, you get some points, and in the end of the year, for example, you get for these special successes, which don't count in numbers of audience also there, but they count in success for the station, because you got a huge prize, for example, for production. So then you also get some money. So we always try to find something to help at all the development situation, because this is what we always say: there is not enough development money in the film business. For example, if you have other industries, they spend a lot of money in developing. Car industry, 25% of everything they spend into this, but film market in Germany is we all develop and spend the money for development, and if we don't get a contract, it's a real big losing situation for us. So,
of course,
yeah.
Olga, you want to come in? Go ahead.
That's a short question. What about the other streamers? Like, for example, Prime, Amazon Prime and Disney. Do you enter into?
Yeah, we will. So what we can do is we can make them negotiate with us. It's also something we can do. So we have no control if there's a good outcome, but we can make them bring them on the table. It's also in the law, so they have to do it. But because we have such a huge problem with everybody understanding what Netflix wants, because this completer thing is something to explain people. And if you count numbers, it's so difficult, because if you have a huge success, you really get a good money out of it. But if you have a middle range success, you don't get so much money. So then everybody's going, yeah, but the Writers Guild is getting all this money for everybody, so why don't we get it? And also Netflix doesn't really understand what's the author's right in Europe is. So, and therefore it's a lot of discussing and trying out and making everybody understand, because the other thing is, we always had a kind of a special range you didn't get in cinema business, for example. Yeah, you could get a lot of money, but in TV station programs, there was not so much money. So it was a good thing to earn, but there were not so big differences in payments between the authors on a special kind of primetime program, for example, for writing 90 minutes feature film or so. But now on Netflix always says, so what's the problem? Because if you come, you're an established writer and you can tell us what you usually want to get for writings for us, so you will get it. So, but we are not used to this. So most of the writers don't believe that. But we know that it sometimes happens. So it's very complicated, because it's also a change in thinking. German writers haven't been so professional in advertising themselves somehow and see it as a business. So because they were used that there was a TV station you worked for, and they always gave you a new contract, you did a new program, everybody was lucky and you got enough money to live. So, but this kind of thinking that you might win with one show enough money for your whole life, it hasn't been realistic in Germany. So, but now it's stuff that we all have to take more risk, for example, and have to have stronger agents. Also, our agents are not really fighting. So there's a huge difference between an American agent and a German agent. So because they'll just go to the station and say, you usually pay this, my author needs to have 2,000 more. So it's and then they say, okay, or you get 1,000 more. So it's very simple kind of negotiating with a public broadcaster, because it's not such a big range for everybody. But now they have to learn to fight with Netflix. It's a complete other piece of cake. So, but we are learning. We also, what we do is we try to build up kind of a community at the moment. So we talk to all the agents, the publishers, and so we are all start to go together and negotiate with Netflix, for example. So we have a huge exchange, same thing as we do now on worldwide or European guild platforms. So we try to build up a kind of force, and I think it's quite necessary.
Yeah, I think that's an important point, that at some point you have to also you have to build consensus within your own community, and that, of course, because we have now the same companies in front of us across Europe and in the world, it's quite important to keep ourselves to keep in touch on the solutions that are found and how we can somehow in practice harmonize a little bit without waiting for legislation to do that.
See, one thing might be important in this. We feel it's a great responsibility at the moment to make a contract with Netflix, because if we agree to something, everybody in Europe has to agree. They will never go over it. That's a problem. This is why we need to talk to each other, not to do something which is, I don't know, might be in the systematic in Spain also is totally wrong also.
Yeah, as it happens, I mean, there are existing contracts with Netflix across Europe by collective rights management or actually guilds, and that sort of is a segue to our next speaker. Christine from Sweden. It would be, thank you so much, Peter, by the way, for your contribution, for the open discussion. Christine, I will leave you to present yourself and to give us a little bit of sort of an overview of where you are in Sweden on collective bargaining with global streamers.
Yes. So. Thank you, Pauline. And thank you for inviting me. Very good to be here. This is my first time. And bonjour, nice to meet you all. My name is Christine Strindberg then, and I'm the head of negotiation for the Swedish Union for Performing Arts and Film. And my background is I'm a lawyer by training. I've worked very much on the other side, the dark side, as I used to call it, commercially with TV channels and platforms and production companies before I came here 2 years ago. So I have sort of that backdrop with me, and it's really interesting to sort of meet myself in the doorway in these negotiations, because I used to be on the other side. But as you might know, CNN Film, which we normally call our union, they have we have a wholly owned subsidiary company called Copyright CNN Film. Used to be Tromb, if you have heard that before. We've changed our name recently. And the Copyright CNN Film company, they have agreements with all the rights holders that we represent, sort of exclusive mandate agreements. And that's why we are able to actually have the power to negotiate these collective bargaining agreements. Otherwise, we'd be doomed, really. And I thought that I would start out by describing a little bit about the landscape, the media landscape that we have in Sweden, which has changed enormously over the past 5-10 years. So we do have like ordinary TV channels still. The public broadcaster, of course, we have a couple of others, but the linear viewing, of course, is decreasing by the moment all the time. So we have now a vast amount of streamers. So of course we have Netflix, we have HBO, we have Amazon, Disney, Paramount Plus. We have 3 local streamers, C More, Viaplay, and then also Discovery Plus. It's going to be interesting to see what happens there with Discovery Plus and HBO, of course, but still they are local. So we don't have Apple yet, and we don't have Hulu or Peacock as you guys do in the States. What we also see is that we need to direct some attention to Spotify, because they recently produced a audio drama or audio fiction, or like radio theater, the old-fashioned thing, where they used, of course, actors, which we represent, and then, of course, audiobooks. We have 3 major sort of streaming platforms for audiobooks, so we need to look at that too. So that's sort of the landscape that we're working with. And if we then look at our agreements, well, we have one sort of collective bargaining base agreement, this, if you would say, which mainly regulates the employment law stuff, sort of overtime and minimum salaries, etc. Very important. But that also provides the foundation to the negotiation of the rights. And there you could say that as of now, we have 2 different types of agreements for the rights. We have one with the producers, well, the employment organization representing the producers, you would say. And that specifies 3 payment buckets, as I usually call them. You have one, of course, the payment for the work, one bucket. And then you have one which is the initial rights remuneration. That basically provides this agreement with the producers is mostly used when it comes to the local streamers. So Viaplay, for example, when Viaplay is producing a TV series, they normally buy 10 years, and they buy it for the Nordic territories. Now Viaplay is expanding a lot, so they're also buying now Poland, Baltics, France, Spain, Germany, Netherlands, etc. So they're expanding the territory, and also US and Canada recently. But they then pay 3% of the budget. This is official on our website. It's also a translated version if you want to have it, for the 10 years in the Nordics. And they have to pay extra per territory that they add. And then the third bucket, payment bucket, is of course the royalty if it gets sold to another country, China or Japan, or we would wish that. That would be very nice. And then we also have the reporting where the distributor or the producer reports back to us and also pays these royalties. It's a sort of a working system, I would say. There are definitely improvements that we could make. I'm sure that there are sales going on that we don't know about around the world, but most of the time, I believe it's working. So that's sort of that agreement. The other rights agreement that we have is with Netflix, and that is from 2020. So it was made by my predecessor, Ulf. I'm sure you've met him. He's now a happy retired person. I call him sometimes, talk to him. He's doing well, but that agreement concerns TV series only, so no feature films. And that agreement then has 4 payment buckets, if you would say. You first have the same first bucket, the payment of the work, the initial rights payment, which is a certain percentage of the budget. I'm not allowed to share that, but that's a certain percentage. And then we have the completer model, the success-based metric. And then we have also the royalty if it gets sold. I mean, it wouldn't, I would say, on Netflix, but you never know. So 4 different buckets. And that agreement is actually up for renegotiation now. It ends year end. And then we are, of course, to evaluate if this completer model has worked at all. So we get a yearly reporting from Netflix on this agreement. And so far, I think it's 2 series that has reached the first completed level and that has received extra payment. The completed model is also set up so that it restarts every 5 years. So if you haven't reached the completed level after 5 years, but you have reached some completers, not the first sort of level, then you get a pro rata payment. So it is a guaranteed success payment, although not, as high as you might have been. And we are negotiating also a feature film agreement with them. which has the same basic structure, you would say. The completed model is a little bit modified because they say that it's easier to consume a film than to consume a TV series. So more viewers would actually manage to watch 90% of a film than 90% of a TV series. So that's why completed levels are adjusted in that. And then when it comes to the other streamers, we are initiating contacts with Spotify and the audiobook companies. We are talking to Amazon. We're talking to HBO. Paramount Plus, they're not really producing local content, so we've sort of paused that for a while. Disney is looking now. They've hired people, I know, in the Nordics that are sort of into local programming. So it's going to be very interesting to see how that pans out. So I think that just moving on to sort of some of the challenges that we have, because of course it's a huge amount of work to negotiate and to try to evaluate, I think, is the real difficulty here. What's it worth? What are 10 years worth on various platforms? Is pay TV, I mean, HBO now wants to buy SVOD and pay TV because of course they had pay TV channels all globally. So is SVOD and pay TV, are they worth the same? If you buy 10 years on both, should it be double then? All of that is really, really difficult, I think, because you always get, they meet you with the arguments that we already heard here today. You know, of course, it's too expensive and, you know, we can't pay that, et cetera, et cetera. But it's really up to us to decide, you know, what's our view? What is it worth? But in the end, of course, it is a negotiation too. You know, what is the market willing to pay? And it's the same with the success-based metric, the completed model. Of course, you can't use the same completed model for Netflix as you have for HBO or Amazon, because you would never get any money at all, because they have so fewer completers or subscribers. So you have to amend this. And that's why you have to, in these negotiations that take so much time and effort, because you really need to get the numbers from them. And then, of course, hope that they don't cheat you on the spot, you know, because it's all their data. So you have to have that. Otherwise, it's impossible to evaluate. It's a success-based metric. I mean, Netflix one is global, of course. But for some, I know HBO says that local content doesn't travel, whereas Netflix says that it does travel, and you can see that it travels. Even they provide you with examples. They've been quite good in that way. I think that providing examples in the film discussion, of course, provided they don't cheat us on the spot, which I have to assume that they don't. So that's also one thing. And to try to make like sense of all this, and also trying to be smart in the long term, because it's one thing what we negotiate now, but no one knows what's really going to happen to the market in 5 years or 10 years. Things are moving so incredibly fast. So we've actually quite recently, with the help of a data analyzing company here in the Nordics called Medievision, we've asked them to provide an analysis of where audiovisual content is going to be in 2026, just to get sort of a view on where is this going. Is it going towards 4 major SVOD players and nothing else? Is it going towards 10 SVOD players? Is it going towards AVOD, which is an absolute, you know, probable scenario if households cannot afford to pay all of these SVOD subscriptions? It's all about what the consumer can pay, really. And then AVOD all of a sudden emerges as, you know, the savior of the day. And of course, if it's online, you also have this possibility as an advertiser to really target the advertising so that it doesn't get tiresome. As we all know from watching linear television, you know, they interrupt as soon as you get to know who the murderer is, you know, a commercial comes up and you're really pissed off. So that can be sort of a limited when it comes to AVOD. And just finally, what the company, the Remuneration company, has sort of, we're getting this analysis in 2 weeks' time. So I don't really know, but they pointed to certain sort of possible scenarios where AVOD is definitely one of them. And of course, various content is also trading on SVOD and AVOD, whereas SVOD is more towards fiction and AVOD is more towards reality TV, which also has an impact on the fees and the value and the remuneration that we can expect. So to summarize, we're extremely busy and it's very exciting, but also very, very challenging and difficult. You know, how do you know if you're hitting the right level?
Yeah, I think that's very, I mean, thank you very much for this. That's very interesting because it also stems from the fact that you are in a position to negotiate on behalf of your member a pretty complete package compared to what other speakers before you have mentioned. You were in a position to consider in the same negotiation fee for work, communication to the public, and success-based remuneration. So it's very you know, like you have a range of things that you can play, and of course then it's pretty critical for you to understand what the valuation of these different points is for the company in front of you. And as you say, all these companies that we have now exploiting what's online have very different business model, and it's not the same negotiation with Netflix or with Prime or even with Disney, because they have also other operations. So I think that it's a world of complexity, but the point about understanding the perspective, the market perspective, and how that factors in. So how you marry the needs of the membership based on their workflow and the different immediate needs, then the interlocuteur, the party with whom you negotiate, and the structure of the agreement and how you are able to negotiate or not, be it thanks to legislation or thanks to your own structure, the way social dialogue and labor relations are built in your country. So it's a lot of different things to factor in, and it is
Definitely
quite complicated and challenging. Bert, you have a question? Go ahead. I think
yeah. Will this research be made available to all of us, Christine?
That will be great, but we're paying quite a lot for it, and the company is quite concerned that it has to be confidential. So what we're going to do is that we're going to get a presentation sort of for the office, and then we're going to provide one for our board sort of solidly. But you know, I'd be happy to, you know, if we can get on a call and we can talk about it, I'd be happy to do that. Just that I can't share it as a whole. Plus, it's really, I mean, I've had those reports before when I was working commercially, and it's really difficult to understand the reports because it's all numbers and, you know, arrows and stuff. So it's easier to talk it through, I think.
Well, thank you. Good to know this.
But that's a good point. I mean, if there is maybe there is something that we could think about in terms of understanding what kind of market research would be interesting for the entire community at European level, and then maybe pool resources to make that happen. That could be, or at least have a conversation about it.
Yeah, and I think it's so important, as previously said, that we share information about this. We were contacted a while back from our Estonian sister organization, because the local streamer Viaplay was in the midst of making a production in Estonia. They recently launched there. And then we talked, and because of, you know, our sharing of information, they were able to negotiate an agreement where they started as a complete buyout and then managed to get a percentage on the budget as a rights remuneration for those 10 years. So I think it's imperative that we share. and talk to each other.
Yeah.
And any questions that I could be, of assistance with, please just email me, and I'll be happy to help.
Right, being conscious of time as well. I know you have to jump off for your next meeting in a second. So, yeah, maybe just one tiny question. I mean, I'm always very excited to hear how you found ways to value the communication to the public rights based on territories and the potential of local territories versus other. Anyway, that's a detail, but no. Basically, my question would just be: do you sense that the transposition of the copyright directive has an impact on your negotiations, one way or the other?
I would hope so. I would really hope so. But as Barbara, I think, also said, that sometimes the fact that we are negotiating collectively and has done so in the past might be an argument actually to say, well, this has been collectively negotiated, so, you're all set. It is fair. But when it comes to the newer amendments of the copyright directive, sort of Article 20, for example, yes, definitely. That is something that we aim to focus on, definitely. And of course, I mean, what we've also tried to do is to make these agreements sort of on a trial basis, which I think is good for both parties, because no one really knows how this is going to pan out. So the negotiations are always made quite sort of in a transparent manner, where everyone says, okay, let's try this. No one is sort of committing to a lifelong model here, and all arguments are fair in the next sort of reevaluation of the agreement. Of course, that's going to be challenging, but so I have some hopes on the renegotiation with Netflix, but we'll see how that goes.
Well, I mean, best of luck to you, and thank you so much for sharing your perspective from Sweden. That was super interesting.
Thank you.
Everybody has been so disciplined and perfect that I feel like we really cannot overrun on time. This has been a 3-hour meeting, which is really, really intense. And I think without any further, I don't know, perspectives or considerations, I will pass the floor to Clement for some concluding words, really. Clement, our FERA chair of the board. Clement, the floor is yours.
Thank you, Pauline. I have to excuse myself because I was late to this workshop. Prior meeting got a little bit long. So I was listening to all participants and all contributors, and it was a very valuable and informative meeting today, workshop. I thank in name of FERA, FSA, and UNIME, who are the organizing organizations for this workshop, to bring us together. It's really important that we share information on probably generationally defining moment when we tackle to better our copyright legislations. It's really good to see progresses in some countries. It's really nice to have a light at the end of the tunnel, that somewhere somebody has done it really well, and we all try to strive to make our legislations better. So thank you to everybody. Thanks to all you who are here participating in this workshop, and I hope we can make in future some more of this kind of projects when we can share valuable information. So that would be all for today. Thank you very much, and thank you, Pauline, for organizing us and moderating this session.
Thank you all. Have a great end of the day. Bye.
Thank you. Bye.